So there's a few number of us already in. So I think now is a good time for me to introduce you to two of our immigration experts who are sitting on our panel. Firstly, Mrs. Nira Segaran. Nira is a senior immigration expert with over 20 years of experience in the field. She comes from a city background and is looking forward to sharing her knowledge with you tonight. So say hi to everyone, Nira, so they can see you.
Hi, everybody.
Thank you, Nira. Now, Miss Soumaya Eddridi is a rising star in the immigration field. Charming and combative, she has been described by her clients as a fierce advocate for free movement. So watch out, everyone, and please say hi, Soumaya.
Hi, everyone, and welcome.
Thank you. So what have we got planned for you guys today? Soumaya and Nira will give you a short 10 to 15 minute presentation about the upcoming changes and the new rules. Soumaya is going to discuss a new way for you to hire foreign graduates in the UK under the new rules, whereas Nira will be talking about what you as a business need to do if you want to employ people from the UK. Now, after the presentation, we will throw the webinar open to all of you for a Q&A session where you can ask the panel questions. Some of you have already sent in your questions, so thank you very much for doing that. I will relay some of your most popular questions to the panel. But if you have any personal questions which are to do with your personal immigration situation, please feel free to email them to us or put them down on your screen on the bar. Further email and contact details will appear at the end of the webinar, so please note down those details, the email addresses, and make sure you get in touch. Now, if any questions occur during the session, please write them down in the bar on your screen. The moderator will then pass them on to me. So he promises I will do my level best to put as many of them to the panel as I can. If I can't answer all of your questions tonight, or the panel can't answer all your questions, those of you who've supplied your contact details with the questions, we will email you back and provide answers to the questions that you've asked. Okay, so on that note, I'm going to hand over firstly to Nira. It's over to you to begin the presentation. Thanks.
Thank you so much, Nish, and welcome everyone to our webinar. Really hope that you take away some key points from today's webinar in terms of what's going to be happening over the next few months and certainly going forward with Brexit and the end of the transition phase. As you'll know, transition phase ends at the end of this year, and a lot of it has been taken away in terms of the focus because of COVID, but the government's really pushing forward the need to really think about your resourcing over the next few months and the way forward for your businesses as well. A new points-based system has been released, and that is due to take effect as of January next year, but a lot of the key changes that will affect your business need to be thought about now. You need to take those actions steadily over the next few months. The key requirement really and the key change is that all overseas workers will require work permission of sorts. Previously, it was the non-EU workers that you need to obtain a sponsor license for and then obviously sponsor them for, or they would get a freestanding visa. But as going forwards from next year, all overseas workers, including EU nationals, will require work permission. So we'll go through the requirements and also sponsor license requirements around those.
Thank you for joining us today and welcome. I hope you're all as excited as I am about the new immigration changes. And in particular, I will be telling you about the graduate immigration route and why this route has been made has made it more attractive, hopefully for you as employers, to access migrant workers who are graduates and are already in the UK. And Nira, as she's mentioned previously, she will be going through the new skilled workers route and some of the changes that come with that. So in order for me to hopefully help demonstrate how this works in practice, I will be introducing to you my favorite Kim in the world. Sorry, that's not the right Kim. Yes, that's the right one. And I'm sure you all recognize her and maybe you're following her. But for strictly legal purposes, we're not talking about Kim Kardashian. We're talking here about Kim Kardashian. So, as some of you might know, Kim was studying a law degree at the US. She's a US national. And for the purposes of our example, let's say that Kim decides to do a master's degree here in the UK in the one and only LSE. So Kim now is in London. She absolutely loves it here. And why wouldn't she? London is one of the best cities in the world, as recently voted by many people around the world. And Kim decides that she wants to follow the footsteps of Amal Clooney and work in the UK. Now, if Kim previously, if she wanted to work in the UK, she would have need to have an offer from an employer, a business or a company that have a sponsor license. But under the new graduate route, Kim can actually stay in the UK for up to 2 years. And if she completed a PhD, she can stay in the UK for up to 3 years and with no restrictions on the type of work she can do. And this route will be available from summer 2021, which means she can work for any company, including some of the businesses that we have with us today. Now, why should you consider graduates when maybe you have not previously considered employing international graduates who are in the UK? So there are some advantages to this route for you as a business. The first one is that you do not require a sponsor license to hire employees who are under the graduate route. And as Nira will explain later on, the sponsor license route can be sometimes quite complex and costly, particularly for small to medium-sized businesses. The second thing is that there isn't the minimum salary that was required under the sponsor license route. This is very positive because it allows you as a business to negotiate the type of salary that works for you. And thirdly, it will allow you to keep those employees in your business for up to 2 years, or as I've mentioned, if they've completed a PhD, for up to 3 years. And it'll give you an opportunity to actually know the kind of employees you have. So a lot of the time you might be having to sponsor graduates, but now you can actually see what their work ethics are like. Are they suitable for your business? Does it make sense to hire them for the long term and go through the sponsor license route? And this route is also really useful for EU citizens who will be coming to the UK after 2021 and studying in the UK. Because this route is also open to them, and after Brexit, there'll be more restrictions on the type of employees you can have. So moving on, let's go back to Kim and see how this works in practice. So let's say that Saracens as a firm receive a surprise CV from Kim, and she actually wants to work with us. She wants to work with the Saracens team, and Saracens are really excited to interview her, get in all that gossip, and also see how she can actually benefit our firm. So after a successful interview, Kim is hired as a brand ambassador, and we now have access to millions of Instagram followers, and she is able to tell the world more about the Saracens brand. So how can Saracens actually in practice hire Kim? What Kim needs to do first is, before her visa expires, meaning the student visa route, she would need to apply under this graduate visa application. She'd need to submit it to the Home Office, and if she meets all the requirements and after an approval, the Saracens as a business can hire her, because then she has the right to work in the UK. But Saracens also need to make sure that they're compliant. So they need to perform the right to work checks, keep a record of her employment. This is just to ensure that they're compliant and no issues might arise in the future. Okay, so moving on. Let's say 2 years from now, after Kim has completed a 2 years contract with Saracens, she's brought in a lot of business. Saracens are really happy with the work that she's done, and they want to keep her on, and Kim wants to stay here in the UK. She loves it. So what can Saracens as a business do to ensure that they can continue to hire migrant workers in the UK? And this is what Nira will be discussing with you. Thank you.
Thank you so much, Soumaya, for that introduction to Kim. And really, we're trying to show you how your employees will be able to obtain the necessary work permission that they need. So essentially, one of the key changes is that there will be called a new skilled worker route. That's part of the new points-based system. This is a massive overhaul from the previous system of the Tier 2 process, and it's a key requirement. It's essentially broken down into two-step process. So if the first thing is that the job itself needs to meet the requirements. So the job that you're going to hire your individual worker for needs to meet the designated skills level. This is broadly speaking A level. Now it's important to make sure that you don't get this confused with the individual holding at A level, but the role itself needs to meet that requirement of meeting A level at least. Now, there is what's called the standard occupation codes, and essentially this is a list of all the kind of job roles that would meet this requirement, the necessary salaries, etc., which we would refer to before issuing a certificate of sponsorship at the time. The salary will need to be 25,600, and this has dropped from 30,000, so this is a welcome change. 25,600 or the going rate. Again, the standard occupation codes relay back to the relative salary. So if you're going to employ an employee who requires this work permission, you'll need to check to make sure that the salary also meets those requirements. There is an English language requirement as well. So if you're from a national country, such as Kim is from the US, then that should be no problem in most situations. But there's also obviously those kind of requirements need to be met by other individuals coming over, not just from overseas countries, but also Europe as well. So the individual needs to meet that. So the second part of the process is that, great, the certificate of sponsorship can be issued, but the company also needs to hold a sponsor license. So you as an employer will need to hold that sponsor license in order to issue that work permission. And the process I'll go into in a second, but the key requirements are that the company needs to be established in the UK. Now, you don't need to be established for a particularly long period of time, but you need to be established in terms of being able to show audited account documentation, you have an office in the UK, and other key requirements as well. You have to have an effective HR and recruitment systems in place as well. So this doesn't need to be anything particularly complex. However, you need to be able to show that you have personnel files, that you know who your individual workers are, and effectively that you're able to track, monitor and report on these workers as well, just like with any of your other employees. So you need to be able to evidence that's part of the application. You have to show that it's a genuine employment reason for actually getting the individual or migrant workers into the UK as well. So the sponsor license application will need to encapsulate that. You don't necessarily need to advertise to show you've done advertising, because that's another requirement that's actually being taken out. However, it's really important that you make sure that the employment is actually genuine. Key personnel are also really important as well, such as have an authorizing officer, so that would usually be the most senior person in your company, and then also you would have other people that are going to be responsible for the sponsor license, who are going to do the day-to-day management as well. As legal representatives, we are often on licenses as well to assist, so we can help with that as well. So then the second part of the process really is understanding what happens once the sponsor license application goes ahead. The first thing is to submit the application to the Home Office, first of all. That's relatively straightforward. That's done online, but obviously you need to make sure you've got all of your documentation ahead of time. The Home Office will come back to you if they don't have the information that they need. It's really important that you make sure that these records are kept up to date, because you could also be audited at any point. So if you are audited, then that could mean the Home Office visiting your offices, checking your HR systems, and basically making sure that you are an established company in the UK. Because of COVID, they're not actually visiting offices at the moment, but we're figuring out basically come New Year, then they'll start doing those visits again as well. Well, as part of the application process, you should also think about future planning. You shouldn't just really tick the boxes in order to get the license and get your migrant worker in. Throughout the course of a license, which is granted for 4 years, you need to make sure that everything that you said you were going to do as part of the license, you actually do, because that could have consequences, which I'll go into in a second, if they're not followed as well. Okay, so just a couple of points that I want to bring out for the application itself. So ensure your workers are working as prescribed from the actual application you make. So they are going to be doing the job role, they are going to be paid the salary, and they're going to be working as, where they are, for example. These seem like little things, but if there are any changes, you need to report them. So for example, if you recruit somebody and they're going to be doing a job role and then they get promoted, you think, okay, we'll just leave that. The sponsor license needs to be updated. And if it's a material change, then there might be it could affect their work permission. So you should always check that before you make any of those changes. Right to work checks also need to be conducted. So I'm sure a lot of you're already doing this, but they need to continue thoroughly, because it's something else the Home Office will want to see. You can be audited by the Home Office at any given point. So yes, like during the application process, yes, that's a possibility, but also throughout the course of the whole license itself, they could just drop in essentially. So you need to make sure that systems are up to date. Breaches can be disastrous on many levels. So reputational damage is a key one, which a lot of companies don't think about, but they do publish a list every 6 months of companies that have had fines issued. There's a 20,000 fine per illegal worker found. And this list will list the company name, the authorizing officer, company location. So you can imagine this list is publicly available. It can be quite reputationally damaging to a company if the rules aren't followed properly. There's financial penalties, like I mentioned, and criminal and civil prosecution fines as well to consider. Okay, so fantastic. What we've done is we have obtained the license, that's been approved, and we're ready to go ahead with issuing what's called the defined certificate of sponsorship. This has recently changed. It's not public knowledge yet, actually. The defined COS is going to be released as of December. I found out about this during a Home Office seminar last week. So this is hot off the press for you. But essentially, it's replacing the old Tier 2 certificate of sponsorship or the work permission itself. So once the application has been approved, the license, then we can issue the DCOS to Kim. And she's able to switch in country because she can, because she's already here on the graduate visa, she can switch in country. But the same way, in order to activate that DCOS, then the individual could apply for entry clearance from their home country as well, if required. A couple of flags that we wanted to put in as well, which is quite important, and conversations that we often have with our clients in terms of costs. There are quite high unexpected costs that companies don't appreciate. So a couple are immigration skills charge, which essentially is a cost of £1,000 per year of the visa issued. And typically a visa is issued, a COS is issued for about 5 years. So that's £5,000 upfront costs already. Then there's the immigration health surcharge, which is £624 per person, and visa application costs, etc. So for the typical move for one person coming under this category can be up to £10,000. Now, if you add on family members, as with, if Kim's got her visa, she's going through the application process, she wants to bring in 30 children, then those costs apply, apart from the immigration skills charge, they all apply to the family members as well. So a family of 5 can cost £25,000 easily in government fees. So it's something to factor into your business planning as you do that going forwards. And it's important because these fees, very previously, prior to Brexit, European nationals, there are no fees associated with any applications for Europeans, but going forwards there will be. So you certainly need to think about that for your business. And processing times, they just vary essentially, so just something to consider as well. Okay, so just the key points, just to summarize for you. All overseas workers will need work permission, regardless of where they will be coming from. Think about who's in the UK at the moment, your current workforce. Currently, if you've got European nationals, they can apply for what's called pre-settled status or settled status. New individuals from Europe and anyone from overseas will need work permission. Sponsor license is needed in order to issue that necessary work permission for them. So think about the costs and the processes. The worker will need to meet the requirements of the role as well, which is key and very important to be met. With the responsibility of being able to issue you that as an employer comes a vast amount of responsibility to make sure you're compliant throughout the whole process. There's high government costs. The key message really is to apply for sponsor licenses sooner rather than later. There's a big push from the government to do that as soon as possible, especially if you're thinking of bringing Europeans in from next year. You'll need to make sure you add, you think about applying for a license as soon as possible. But essentially, it's a great opportunity for your business because you are able to recruit many individuals that you wouldn't have been able to before, in terms of, at least it's a route in terms of a lot of people were worried following from Brexit that, what's going to happen to the business. There is a route. They have relaxed the rules and the requirements. And essentially, you have to be thinking about the talent you want to bring to your business in order to grow it in the future as well. Thank you very much. I'm going to hand back to Nish.
Okay, brilliant. Thank you very much for that presentation, Nira and Soumaya. That was extremely comprehensive and very, very informative. It certainly raised a few questions in my head, not least about Kim Vandashian and her husband, what was his name? Kanye East. But I'm sure it raised a few questions in the minds of the audience as well. So I think now would be a good time for me to put to you some of the questions that have been coming from the audience for you guys. I think I'm going to start off with a question that's come up again and again so far. And I'm going to address this one to you, Nira, if that's all right.
Yeah.
What happens in the event of a sponsor license being refused by the Home Office?
Okay, this is quite an interesting question because the Home Office usually would come back to us before an application is refused. They have been quite helpful of recent times, and I think it's really the government trying to appear to be more friendly and helpful to businesses and more business friendly. However, if an application is refused, unfortunately, it can't be appealed. So really you would have to look at the reasons for refusal and see whether there's anything that can be done at that point. Although there's no kind of technical or formal way of overturning a decision, we do have good relationships with the Home Office. So we do try and, if it's a reason that is uncalled for or unreasonable, then we would try and, liaise with the Home Office to get that overturned. It doesn't affect your applications going forward too much, depending on the reason, really. Many applications are refused because of lack of documents and not meeting the requirements sometimes.
Okay, so from my understanding of what you're saying, if it's refused, there is no avenue of appeal unless there is something manifestly wrong or nonsensical, say, for example, in the Home Office's reason for refusal. And in that case, I guess what you're saying to me is it's not a question of what you know, but who you know. And if that is the case, then the refusal can be reworked with the Home Office.
Correct.
Yeah. Okay, brilliant. Okay, thank you very much. That's very useful to know, and I'll make sure that if they refuse anything, I'm going to come straight to you, Nira, so you can use your connections. Okay, there are a lot of questions landing, so I'm going to move on quickly to the next question. The question is, do all international employees need work permission? And this is employees in the EU or EEA and outside. Can I put this question to Soumaya, if you don't mind?
Of course, thank you for that, Nish. I think that's quite an important question, and there's a few things to consider. So the first thing is, if you have currently EU nationals who are your employees employed in your business, that you would not be required a sponsor license to have them as employees. But what you need to make sure of is that they've applied for the pre-settled status or the settled status before June 2021 in order to continue to have the right to live in the UK and work in the UK. Now, after January 2021, for all EU nationals who are coming to the UK, you will need to have a sponsor license in place, usually to hire them and for them to work for you. So this is why these changes are quite important. Now, for non-EU nationals, currently you would need a sponsor license, and after January 2021, you would usually need a sponsor license. But there's one thing to note: not all non-EU nationals might need a sponsor license. So they might actually have the right and permission to be in the UK under a different type of visa. So for example, they might be spouses of British citizens and they have a spouse visa, and that usually would give them the right to work in the UK. So the thing to look for, and essentially the first steps when you're hiring someone, is to first check what permission they have to be here in the UK, and whether, based on that permission, you would need to have a sponsor license in place in order to hire them, and in order for them to, for example, if they're already working for you, for them to continue to work with you as a business. I hope that answers the question.
Yes, thank you very much. It does. It's a question which is coming up again and again in different forms. So I may come back to it a little bit later, depending on the number of questions that come up. The next question is from a gentleman saying that he employs a migrant worker. Does he need to increase their salary from January 2021? I'm going to put that question, if you don't mind, to Nira.
The short answer is no, he won't need to make any changes at all. So if he's already employing a migrant worker under the Tier 2 category, he won't need to make any changes to that particular worker's situation or increase their salary. The sponsor license itself will automatically transfer to the new sponsor license system and the new regime, but current employees won't be affected.
Okay. And that applies to all migrant workers, right?
Yeah, correct.
So, okay, fantastic. All right, while we're here, let me ask you the next question, which is coming up. A lot of people are asking when they should be applying for these licenses.
Yeah, I mean, that's a good question. And as I touched on before, it's a real drive at the moment to get your applications in before the end of the year. Now, as we know, as of next year, there's going to be a whole new system in place. If you're planning to bring in European workers from next year, you'll need to make sure that you have your sponsor license in place now. There's a big drive towards the end of the year because there's a couple of reasons. The Home Office are likely to see a flood of applications as soon as, in the next few months. So it's best to get that in now. There's different types of routes as well. So there's fast track routes. There's a new one that was released last week where you pay £500 and it's fast tracked. It's also good to take advantage of the fact that they are not doing audit visits. Slightly sly, but still, if they're not going to visit you at the moment, you should take advantage of that. But essentially, it's good to get the application sorted out now. It's future planning more than anything else.
Okay, and at the same time, when would it be too late for them to apply for a license or to do anything about this?
I don't think it's really too late as such, but in terms of you can apply for a license at any given point. But in terms of future planning, if you want to be prepared for any business expansion plans you have for next year, and you think, right, I might need X amount of people from Europe, it's best to get your sponsor license application sorted out now, whilst the iron's hot, as they say, so that you can future plan for those moves. Otherwise, at the last minute, you'll be faced with the administrative burden of collecting the documents, making sure your compliance is in order, submitting an application, and it's all very rushed. So, even though it's a quick processing time, if you pay the fast track route, getting to that point can be quite administratively cumbersome for a lot of companies, which is important. Why you should essentially plan now.
Okay, and on that same note, what would you do for these companies who are looking to apply for a license? What is it that you would actually do? So say, for example, they've listened to the seminar here today, they want to process the application, they drop you a line. What would you do next in terms of what would you do for them?
So I'd really want to understand their business needs. So what are their future plans in terms of their workforce going forwards over the next year, and then going, after a year, essentially. We would then progress with the sponsor license application, understanding about the business, collecting, advising on the necessary documents, and submitting the application as soon as we can. We also liaise really closely with the Home Office. So if there's anything missing, if they need more information, then they do work with us quite closely as well, which is an added bonus. We have a high success rate in terms of sponsor license applications because we ensure that the application is in its best possible, situation before it goes to the actual Home Office, and then we liaise with the Home Office afterwards. So the next steps are really to understand the business and to take it forward in terms of application processing.
Okay, thank you very much for that, Nira. The next question is slightly different, and I'm going to put this one to Soumaya, seeing as you touched on it earlier. Soumaya, how long does it take to process a sponsor license application? And this again is a repeat question a number of people have asked.
So it typically takes around 12 weeks to be processed. But the Home Office are introducing the fast track route so that businesses can basically process that application quicker and get the needed workforce as soon as they possibly can.
Okay. So that just applies for EU nationals who are in the UK already, yeah?
Sorry?
That applies for EU nationals who are in the UK already.
So this is for the sponsor license application in terms of the processing time for the sponsor license application. For EU nationals who are already in the UK, they will usually not require a sponsor license in place to work. But what they, as I've mentioned previously, what they will need is actually a pre-settled status or settled status application. So they need to make sure that application is submitted before the 30th of June in order to retain the rights to continue living in the UK and working here. So yeah, that's for EU nationals who are already in the UK.
Okay, all right, I understand that. All right, Nira, I'm going to put the next one to you. What actions, this is the next question, what action would I need to take before January? I know you touched on this earlier as well.
So look at your current workforce and really understand, first of all, have you got European nationals who need to apply for pre-settled status or settled status? Communicate with them that they need to do that as soon as possible. And really think about future planning. Who do you need to work next year in order to grow your business? I mean, we are in unprecedented times at the moment, so it's quite difficult to do that. But it's certainly something that you need to be thinking about towards the end of next year at least, and start planning for that immediately.
Okay, so they need to look at their EU nationals that they have on board at the moment. Is there anything they need to do in relation to non-EU nationals?
Any non-EU nationals that they might have working for them, hopefully they would already have work permission. Anybody that's going to be arriving after January the 1st, they'll be in the same process anyway at the moment. So if you've already got a sponsor license, then you can continue with that. But then if you're thinking, right, we need to employ somebody from any country from overseas, then get your sponsor license application submitted as soon as possible. It's a lot less painful to do that now as opposed to later on when you're stuck with having to go through the whole process at the time. And when there's a lot of government focus on it and a lot of support from the government in terms of understanding the business, it's best to get your application in now.
Okay, brilliant. Okay, all right. Soumaya, I have a question for you, if you don't mind. Somebody has asked, can I switch from an ICT to a skilled visa after having completed 5 years in the UK?
That's a very good question and an interesting one with these new changes. So just to give a bit of a background, an ICT is an intercompany transfer. It usually works where, for example, let's say we've got an organization that has a branch in the UAE and has a branch here in the UK, and they want to transfer one of their employees who's based in the UAE for, let's say, 5 years in the UK, and then following those for a particular project, let's say. So, but that employee is essentially still employed by the branch in the UAE. And usually this route would not give you eligibility for indefinite leave to remain, for example, after 5 years. But under these new changes, which are very positive, those who are who have an ICT visa can actually now switch to a skilled worker visa, which means that they will be able, for example, to continue working in the UK. And once they've accumulated the required period of time of residency, they can apply for indefinite leave to remain. So yeah, it's quite a positive change.
Okay, all right. Okay, thank you. That was a comprehensive answer. There are a couple of people asking, you mentioned pre-settled status. Could you explain what that means, Soumaya?
Yes, so essentially, when Brexit happened, the government needed to make sure that those who are already in the UK, EU nationals and EEA nationals, are protected. So they've introduced the EU settlement scheme, which has both the the pre-settled status and the settled status. So the pre-settled status is for EU nationals who have not been living here for 5 years, for example, continuously. And however, they wish to continue living in the UK and, for example, working or studying. So they would need to apply for the pre-settled status. Now, for those who've already accumulated 5 years of residence, usually they should be eligible to apply for the settled status. And when you're actually completing the form, they don't ask you which one, because based on the details you provide them and how long you've been in the UK, they would determine which one you're eligible for. One thing to point out also is that there are some EU nationals who have been living in the UK for a very long time, and they might have what we know as permanent residence. So they also would need to apply for the settled status, even though they do have something that tells them you're a permanent resident in the UK. Under this new scheme, you would have to make sure you submit an application before the 30th of June 2021. And that also applies to EU family members. So not only to EU nationals, but you might have EU family members who are not EU nationals, and they will also need to apply for the pre-settled status or the settled status. Yeah, I hope that answers your question.
It does. It surely does. There are a couple of questions, apologies, that have come up, which relate to food and chefs. I'm going to put that to you. Soumaya, if you don't mind, you answer the last question. The question is, do chefs remain on the shortage occupation? Now, it doesn't say are they any type of chef or if they're a Michelin star chef, etc. But that is a recurring question. So do chefs remain on the shortage occupation list?
The short answer is yes, they do. However, there are requirements. The chef needs to be a specialist in their respective area of cooking. And they need to have at least 5 years experience. And yeah, so essentially they're still on the shortage occupation list, which is very good, given that, you know, the UK has a booming restaurant industry. So for those businesses who work in the restaurant industry, and you might want to hire someone from abroad who specializes, let's say, in a particular type of sushi, you might be able to hire them, given that they meet the requirements. So it's a good thing to still have. Okay, fine.
I've just got, hopefully that's for... I've just got something which is similar to what you talked about before, Soumaya, so I'm going to go back there. Apologies if you've already answered it, but again, it's a simple question which says, what has changed with the ICT Tier 2 visa? Apologies if you hit on it before, but if you could give us a quick breakdown of what has changed with the intercompany transfer on Tier 2.
Yeah, so what has changed is that now you can actually switch to a skilled worker visa. Previously, if you're on an ICT visa, you would not be able to switch. If you were here, for example, for 5 years, after your 5 years are complete, if you wanted to switch into a different category, let's say you have a job offer from a company that is in the UK, you can't simply switch to it. But now you can, and it's quite a, again, as I keep mentioning, these are positive changes, because let's say the company want to retain this person, but they want to retain them on a skilled worker visa, as opposed to the ICT. They want to keep them here for the long term. And the ICT visa have certain requirements that the Tier 2 visa doesn't have. For example, certain salary requirements if you want to continue to employ the person. So it's a quite positive thing for many businesses, and particularly those organizations that have individuals on the ICT and want them to switch over. So the short answer to your question is that the change is that you can now switch from an ICT to a skilled worker visa.
Okay, brilliant. Thank you. That's very comprehensive. Guys, I'm getting a couple of questions from people asking for costings in detail for different types of visas. I know Nira did go into some of the costings just to give you an indication, but we're not going to go into the individual costs of each visa because that is going to be too onerous, and that's information which is readily available. Remember what I said, if you have any questions, please put them down on through the chat box, or by email, and we will respond to all of the questions, even the ones that we cannot respond to at the moment. All right, so thank you. There's a bit of an essay here, which I'm going to turn into a question. So somebody got a residence card during 2020, but she was forced to spend more than 6 months abroad because of the pandemic. does she have to reset her pre-settlement status? So I'm not going to repeat the other facts, but I guess the question is, if people had status, they went abroad and there were delays caused during the pandemic, is that going to affect their pre-settlement status? Do they have to reapply or reset it? I'll put that question to Nira.
Yes, that's a really good question. And I think over the last few months, we have had a huge influx of queries and applications, essentially, of people that have been affected immigration-wise by the pandemic for various reasons. And this ranges from travel to financial difficulties, etc. Now, the Home Office have made a general announcement that no individual should be negatively impacted immigration-wise because of the pandemic. So whereas before, in this current situation, going back to the residence card and whether that's going to affect the pre-settled status, usually that would have done in terms of it being an extended leave amount of time outside of the UK. But in this situation, I would advise that essentially it would be about, when time comes in terms of making an application, that you collate the necessary information to show that she was outside of the UK without cause of her own, flight details that you might want to retain on file for the application, anything, any correspondence, any news items, essentially. And if that is submitted with an application, then the Home Office will consider it. And we've been dealing with the Home Office on these type of situations for some time now, over the last few months, and they have been very accommodating, I have to say. So it's going to be discretionary, but essentially there's certainly room for manoeuvre in this particular.
Okay, so does that include compulsory lockdowns or isolation periods imposed by other countries?
Yeah, definitely.
It does,
so any impact from COVID, definitely put it into an application where you have been, where your immigration status has been impacted. The Home Office have made a very clear announcement about that. So an application can be submitted, and it shouldn't impact any immigration status in that event.
Okay, all right. Another question which has just popped up. I'm going to put it to you, Nira, simply because you're unmuted at the moment. So what happens if an employee marries halfway through employment and has children, maybe? Is the employer responsible for paying the dependents in that situation, for the dependents in that situation?
All right. Okay. So in terms of a new DCOS or work permission that the company is sponsored for, no, the employer is not responsible at all at any time for dependents, essentially. The responsibility will always lie with the individual, the migrant who's got the certificate of sponsorship to work in the UK. As an employer, you're responsible to ensure that they're doing the role that they're going to be doing. The costs you'd have to cover are things like the immigration skills charge, certainly, because that's a government incentive. But other fees such as the immigration health surcharge, dependents, don't need to be included, and that's not your responsibility as an employer.
Okay, brilliant. Thank you for letting us know. I'm going to put the next question to Soumaya. And the question is that if an EU candidate based in the UK already has EU settled status or pre-settled status, they apply for a new role after January 2021, does the employer need a sponsorship license to recruit them?
A very short answer, no, because they already have the right to be here in the UK and they have the pre-settled status or the settled status. So they can move from different employers without any restrictions, and the employer would not require a sponsor license to hire them.
Okay, brilliant.
Thank you.
Okay, that was short but sweet. Thank you very much for that, Soumaya. Right, I have another question. Like I said, I promised I would try and get through as many questions as I could. My employer is an existing Tier 2 sponsor. So can they now directly apply for a COS, for a skilled worker visa from next month on, or I guess do they have to do something different? So there's an employer they are a tier 2 sponsor, can they now directly apply for a COS for a skilled worker, or is something going to change from next month onwards? I'll put that to you, Nira, if that's all right.
Yeah, of course. So nothing will need to change. If they already have a sponsor license, then current sponsor license holders, they will automatically be transferred to the new skilled worker sponsor license. I understand that's happening as of 1st of December, as opposed to January. That again is hot off the press. And accordingly, they'll be able to issue what's called a DCOS, which is a defined certificate of sponsorship, which equates to a tier 2 certificate of sponsorship. So the employer who holds a sponsor license will not need to take any action at this stage in terms of transferring their license.
Okay, all right. And there is a general question. I know I said I would not go into too much detail about costs, but I am being asked again and again, what is the general cost for a sponsor license?
The costs vary, essentially depending on the size of your business. The cost for a small to medium company, I believe, is in the region of about £500 for a sponsor license. If you're a larger company, then that's if you've got over 50 employees, then it's in the region of £1,000, I believe. And that's just the sponsor license application alone.
Right. Okay. And then what are the costs on top of that the companies have to look out for?
Sure. So as I mentioned, and I'm not surprised, and it's very prudent for companies to think about that, because it is a surprise. Because you think, great, I've got a sponsor license, and £500 isn't too expensive for a sponsor license, actually. But the cost mounts up in terms of the COS, or the work permission, that you're going to have to issue after that. So the certificate of sponsorship is £199. That's fine. The entry clearance application itself, or the switching application, is around £600 per person. Again, not too bad. But then it gets interesting in terms of the cost to the business. So the most important one is the immigration skills charge, which is £1,000 per year for the certificate of sponsorship that's issued. So, and this is for a large company. For a smaller company, it's in the region of about £300 per year, approximately. So for about 5 years, you have to pay that cost up front. So a 5-year visa will cost £5,000. Then the controversial immigration health surcharge, which is a cost to the NHS, that has recently been increased as of October 22nd to £624 per year of the certificate of sponsorship per person. So just for one individual, then you're looking at 5 years, and my maths isn't great, but you're looking in the region of about £6,000 to £7,000 in total for one individual, just on those two costs alone. And those are pretty much the highest costs that you'd be incorporating it. But don't forget, if somebody's coming over here on a skilled worker visa, they're likely to want to settle in the UK. So usually people will have family. So that would be at least a spouse and perhaps children thereafter. And those costs will need to be met. In terms of, I was just going to say, in terms of businesses, what a lot of businesses do is that they wrap those costs up into the offer that they make to an future employee. They also put in recruitment policies. So, for example, if an individual was to leave the company within 2 years of joining the firm, that they're expected to pay back those costs.
Okay, sensible.
So those are things that you can think about as a business. There are costs you have to pay. So the skills surcharge you have to pay as a business. The other fees, the health surcharge, that's not your responsibility necessarily, but those charges are there, and they will need to be passed on to the employee if that's not yours.
Okay, that's good to know, because I'm sure there's a lot of companies that think they're responsible for the majority, if not all, of those costs. But that is, I guess what you're saying is that is negotiable. And that's part of the negotiations you would enter into when you're hiring somebody. All right. Thank you very much for that. I'm going to rush through because we're entering our last 5 or 6 minutes, and I still have a few questions that are coming through. One of them I'll just put to you quickly whilst you're there, Nira. Are there restrictions about taking on a second job or if the employee wants to start running their own business during the process. Is that permitted? Is that allowed?
You can take on supplementary employments once you have your certificate of sponsorship. So the supplementary employment can be up to 20 hours per week, but it has to be in line with your role at the moment. So, for example, Kim is a brand ambassador, so she'll be working as a brand ambassador. She can't decide suddenly to, I don't know, become a lawyer in the evenings. Or anything else. So it has to be in line with the work that you already have for your certificate of sponsorship that's been issued to you.
Okay, brilliant. Thank you. And just a quick one for you, Soumaya. I know you have touched on this twice already, but again, like I said, it comes up again and again. The question is, do EU nationals only require sponsorship if they don't already have settled or pre-settled status? So do EU nationals only require sponsorship if they don't already have settled or pre-settled status?
So EU nationals will require sponsorship if they come to the UK after the 1st of January 2021. So that's when they would require sponsorship if they want to work here in the UK. For those already in the UK, let's say you're an EU national who doesn't have settled status in the UK or pre-settled status, but you've been here for, let's say, 2 weeks. You don't require a sponsorship, but you should ideally look to apply for the for the settled status or the pre-settled status, because that will mean that it'll be much easier for you when you go to apply for jobs. And your employers can check that you have the right to work in the UK, and you won't have to go through any issues after the 30th of June where you've actually been here and you haven't formalized your stay in the UK. The applications are pretty simple. They're not too complicated. It involves downloading an app, filling in an application form. The Home Office don't actually require a lot of documents as perhaps required with permanent residence application. So it's a pretty straightforward application. It's something that we can assist with. So if you do have any questions or if you want assistance with that application, feel free to get in touch with us. But hopefully it should be quite a straightforward application for those already in the UK and the EU nationals already in the UK.
Okay, brilliant. Okay. I think we have time. We've only got 2 or 3 minutes left, but can I hear from the both of you quickly in relation to whether you think these new rules are fair, or if they are actually more complicated than the existing rules?
I'll start off. I do think they are, there's some welcome changes with this process. If you know about the Tier 2 visa process and the requirements before, there have been many changes with this with the new points-based system, such as no need to advertise the role to recruit your resident worker. The kind of cap that was in place before has been dropped. The salary level has been dropped. The requirements for a job role has lessened. It was a degree level job that needed to be done before, now it's A level. So I think those are welcome changes. However, I do think that the Home Office are being quite clever in marketing this in a way that is attractive, because essentially before your EU employee that you would have to pay zero in order to start work in the UK, would have to do little processing. They have kind of switched this around now, so the individual, the company will need to pay essentially up to £10,000 potentially in terms of Home Office fees. So kind of to take away from that that focus, I think the Home Office has been quite clever in drawing EU workers into this process and making it as streamlined and as and trying to show them as business friendly. I do think it's fairer. However, I'm not quite sure whether the bringing European nationals into this is right. In terms of complexity, yes, it is. The process is slightly less complex than it was before, but things remain to be seen. As I said, the new sponsor license application is coming. The process is coming into effect now. The new decos is coming into effect, so things remain to be seen as to whether it's actually going to be less complex. Yeah, those are my thoughts.
Okay, brilliant. Thank you for those. Soumaya, do you have anything to add?
Yeah, I agree with Nira. I think these changes are welcome changes. I think the Home Office have put these changes so that it encourages companies to hire the migrant workers, the talent they need, to ensure that they have the workforce necessary to help their businesses grow, to expand, and to bring in the revenue that is helpful for their company. So I do think these are welcome changes, and there are other changes that we haven't touched on, but the Home Office have considered different sectors and how the UK's exit from the EU will affect these sectors. So there have been other changes in terms of immigration rules. So just keep an eye out on our pages, because we will keep you posted and updated in relation to these. In terms of whether these rules are complex or complicated, as Nira mentioned, we are yet to see. So far they look good, and it seems like the process has been simplified slightly, but there might be some things that might become more apparent in the future. So, but then again, that's why we're here, to help you get through this process, hopefully as smooth as possible.
Okay, brilliant. Listen, thank you very much indeed for answering all of the questions that you have done. I'm afraid, ladies and gentlemen, we have or are about to run out of time. So I just want to thank you all very much for attending this webinar. I certainly learned a lot here today, and I hope that you did too. Now, my apologies if we were unable to answer all of your questions. I can see a whole plethora of questions which remain unanswered. Thank you for sending those questions in. If you sent them in with your contact details, we will privately reply and send you email responses to your questions, and we will be in touch. Now, the rest of you, if anything occurs to you in terms of new questions you want answered, put them down in an email and send them. Details are on your screen at the moment. And I just want to finish off by saying thank you so much to our panel today. Thank you, Nira, and thank you, Soumaya. Thank you for sharing your time and your expertise with us. And for everybody in the audience, thank you for attending. I wish you all of the best. And until we meet again online, maybe in our next webinar or in person, I wish you all a lovely evening. Thank you very much.
Thank you, everyone. Have a lovely
evening. Bye-bye. Bye-bye.